Yes, I am the man that is that person.
So you're Gordon Cooley?
Yep.
Very well. State appears by Jill Gillette, County Attorney. Mr. Cooley, there's been an amended complaint filed on, it looks like April 17th. You're charged with driving while suspended as a second offense for on or about March the 25th of 2024 in Elk County, Kansas. If indeed you have a prior conviction where this would be a second offense, that's a Class A misdemeanor. A Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Additionally, with a second offense for driving while suspended, there's a mandatory 5-day minimum sentence. However, a person can be placed on probation from that. But there is mandatory sentence that would have to be imposed. Do you understand what you're charged with?
Here we see the first cracks of the sovereign logic. Gordon's claiming mistaken identity. Classic move number 1 in this playbook. He says he was just carrying property from point A to B, which sounds poetic, until you realize he's describing driving on a suspended license. The judge stays remarkably calm, laying out every detail, charges, penalties, even his rights. This is what due process looks like: firm, fair, and patient. But Gordon isn't here for logic. He's here to make a statement, and that's where things start to unravel. Question for you. Should judges even engage these pseudo-legal arguments, or just cut them off immediately?
I think this is a matter of a mistaken identity. My persons was never involved in anything. I'm carrying my property from point A to point B. There's no vested interest of the state to even stop me. I'm exercising my God-given constitutionally protected rights, and I stated that to the man acting as the police officer. I didn't present him with a license.
You are charged, sir. Hold on. You're charged with driving while suspended, a second offense. That would indicate to me that you've had a first offense.
No.
Have you been in court before on this type of charge?
Nope, not on driving while suspended. No, I have not.
All right. Well, that is what you're charged with. You don't have to agree with it. You can certainly, that is an issue at trial if you feel you have a defense. As with the others that I've explained, you have certain rights. You are charged with a misdemeanor, so you are entitled to be represented by a counsel. And if you wish to apply for court-appointed counsel, if you meet the financial guidelines, I would appoint one to represent you. You also have the right to represent yourself. You also have the right to have counsel of your own choosing at your own expense. So at this time, if you wish to have a trial, if you wish to speak with an attorney or counsel, would he qualify under any programs you have since you charge this as a second offense?
No.
All right. So apparently diversion wouldn't be an option for you. So if you're wishing to have a trial or to speak with an attorney, your plea at this time should be not guilty. If you wish to plead guilty, then we'd proceed to sentencing. But based upon what you're telling me, those would be issues that could be addressed at trial. So at this time, how do you wish to plead?
I don't plan to plead.
This is where it really heats up. Gordon refuses to plead, saying, "I don't plan to plea." That's like saying, "I don't plan to participate in gravity." The courtroom doesn't stop functioning just because you don't acknowledge it. The judge gives him every chance to make a rational choice: plead not guilty, request an attorney, or prepare for trial. Instead, Gordon throws in philosophical questions about injured parties and cause of action, none of which apply to a suspended license charge. It's moments like these that show how fragile courtroom patience can be. The judge knows the law. Gordon knows. YouTube conspiracy threads.
Okay, I exercise my right to trial by jury then. I'd like to face the man or the woman that claims I've done them harm or loss.
Mr. Cooley, if you wish to have a trial by jury.
I'm Gordy. I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person.
All right. Mr. Cooley.
Can I ask you a question?
you need to be quiet for a moment. I'm going to explain what the situation is. You have the right to be represented by counsel. You've entered a plea, refusing to enter a plea, which is fine. A person can stand mute, and I will set this matter for trial. If you wish to be or have a jury trial, you have the right to do so. However, you need to do that in the proper form. With a misdemeanor offense, you have to file a written motion for that request. Otherwise, it's set before the court. So you would need to do that in a timely way. If you're going to represent yourself, you would have to follow the rules as though you're an attorney. So all of those things would, most people don't have the training to where if they're going to do a jury trial, they're better off being represented by counsel. But that's a choice that you're going to have to make.
Okay, can I ask you a question?
Yes, you may.
Can there be a valid cause of action without an...
Now Gordon's going full sovereign. He declares he's a man, not a person. That might sound deep at a poetry slam, but in a court of law, it's meaningless. The phrase comes from a belief that legal systems only apply to corporations or fictional entities, not flesh and blood humans. Spoiler, that's not how laws work. The judge's composure here is gold. Instead of arguing nonsense, he reminds Gordon, you have rights, but you also have responsibilities. Viewers, here's a thought. If you were the judge, would you keep your cool or call security 5 minutes in?
Sir, that's not a valid question for what we're doing here today.
I've tried settling this matter in the private twice. If you have any papers in front of you with my signature on them, it's because that another man and throw them in a box when they have harmed no man or woman, no claim has been brought against them.
You need to be quiet now. We're going to give you a court date, and you can advise me how you're going to proceed at that court date. If you're going to apply for a jury trial, then you'll need to make that application by that time. Otherwise, you'll be set for a bench trial. That's before the court. Sarah, could you give us a date, please?
What sort of time frame would you like, Judge? 30 minutes?
Approximately 30 days, 30 minutes would be fine.
We can do May 15th at 2:30.
Judge, I'm out that afternoon. We could do 11:30 if there's nothing else scheduled there.
We put that for a trial for an hour, didn't we? So
If you only need 30 minutes, we could do the 11 to 12.
Well, we said something at 10:30, I believe, or was it the 10 o'clock that was set for trial?
It was the 10:30 to 11:30 that was set.
Okay, let's set this at 11:30 for a pretrial. So, Mr. Cooley, you will need to appear at the courthouse in Howard. And if you're going to file a motion for a jury trial, you need to have done so by that time.
This exchange perfectly captures the divide between belief and law. Gordon keeps insisting the case be discharged because no injured party exists. But in legal terms, the state is the injured party because it enforces traffic safety for everyone. The judge calmly explains deadlines, motions, and legal steps. Gordon interrupts again and again, claiming he's not part of the legal society. Yet here he is, using its systems and paperwork. The irony is thick. You have to respect the judge's restraint. He's schooling Gordon without ever losing his professionalism. This is judicial patience at its finest.
If you're going to hire an attorney, you need to do that. If you're going to apply for an attorney, I would suggest that you do that as soon as possible, so that you can have counsel at that time.
Am I going to be able to face the man or the woman that has a claim before me, or are you going to discharge the matter? If there's not a man or a woman here, then this matter needs to be discharged.
Sir, I've heard these arguments before, and those are not legal arguments. Somebody's made these things.
I'm not a member of the legal society.
Sir,
Can you bring the law to the court, please? Can we bring the law to the court?
Mr. Cooley, stop interrupting. At your hearing, if you have motions that you wish to have heard, you can file them in advance. I would strongly recommend you be represented by counsel. But your court appearance is May 15th at 11.
Morning.
Good morning, sir.
How you doing this morning?
I'm well. How are you?
Fine.
Morris had previously, there was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
When Gordon refuses to enter a plea, the judge steps in and does it for him, entering not guilty by default. That's standard procedure. You can't just opt out of court like it's a social club. And here's the funny part. Gordon starts mumbling pseudo-Latin like, demurs is not acquiesced, it's pure courtroom theater. But the judge doesn't play along. No sarcasm, no scolding, just calm order. This moment teaches a real legal lesson. Procedure protects everyone, even those who reject it. Without it, chaos would rule the courtroom. Would you keep watching if every trial turned into this kind of philosophical freestyle?
Representing you. Probably want to talk to Mr. Hill before you say anything. We're recording this proceeding, so anything you say may be used against you. But I'm listening to whatever you want me to consider.
I'm not real sure what Mr. Morris is trying to claim in that writing right there. Said he's not
A secured party creditor under the UCC 1 filed in Florida. American national being held in custody in Gulf County, which is not a 14th Amendment citizen of the United States. Not a record. So documentation, which is official records. To state it. I'm the agent of the said principal.
Who wrote that for you?
I did.
Why do you need to read it if you know what you're talking about?
This memory.
Okay. Tell me what the 14th Amendment says.
That you are considered a slave under the 14th Amendment.
That who's considered a slave? I'm not a slave.
No, the incarcerated person. This, if you commit a crime.
Okay. Doesn't say if you commit a crime.
Or yeah.
That's not what it reads.
I got the 14th Amendment really wasn't in the book.
What book?
The book that we had in the back.
What book do you have in the back?
It's a law book.
What law book is it?
Florida statute book. Yes.
So the 14th Amendment isn't in the Florida statutes? That's because it's an amendment to the U.S. Constitution.
Mm-hmm.
So you don't know what the 14th Amendment reads?
The 14th Amendment reads, not off.
Gordon escalates his rhetoric by claiming he signed court documents.
Now Gordon tries to go constitutional scholar mode, quoting the 14th Amendment, the UCC, and something about being a secured party creditor. Translation, he's combining real legal terms with made-up meanings. The judge gives him a chance to explain, and Gordon can't. He doesn't even know what the amendment says. This scene exposes the hollow core of sovereign ideology. It's all performance, no substance. Yet the judge uses the moment as a quiet masterclass in law. He doesn't humiliate Gordon. He just asks for facts, and the silence speaks volumes. Question for you, should judges educate or just adjudicate in cases like this?
One reads.
I wish I had my documentation in front of me to present it all the way. I wish I had someone here that was supposed to be here so I can have it.
I asked you who wrote that for you. You said you did.
I wrote it. Yes.
So do you know what you're talking about?
Yes, sir.
All right, so tell me what the UCC 1 reads.
It's the Uniform Commercial Code filed with the Secretary of State or within the entities under the contract with the Secretary of the State to maintain uniform commercial code records and database of judgment liens maintained by the Secretary of State.
Oh, tell me what UCC 1 reads.
It's a statement and it's a financial.
You don't know what the UCC 1 reads, do you?
Not on top.
You're not prepared. You're not prepared this morning with your sovereign citizen argument. You need somebody. Usually, when sovereign citizens come in the courtroom, at least they can recite from memory a lot of the stuff they travel under. So next time you want to come with your sovereign citizen argument, Be prepared, okay? I'll listen to you, but be prepared.
Yes.
But you're not doing justice to your fellow traveling nationals who consider themselves sovereign citizens if you're not prepared to even articulate what the argument is, all right?
Yes, sir.
All right, we'll see you May 9th at 1:30.
Today.
Be prepared next time, all right?
Yes, sir.
It should have a constitution in the back so you can read the 14th Amendment and be able to tell me what it reads. And
What it says right here, what is state?
we're gonna, May 9th at 1:30.
Machine into a contract.
That's not a contract. That's giving you notice that you're
Yes,
gonna
sir.
come back.
Just making sure.
You're fine. I'm not going to query you.
And that's how this courtroom standoff ends. Not with fireworks, but with order restored. The judge keeps the process intact, setting a trial date and reminding Gordon of his rights. The key takeaway? Courts run on evidence, not emotion. Sovereign citizen beliefs might sound rebellious, but in practice, they only waste time and hurt the people clinging to them. The law doesn't bend for ideology. It stays steady, just like this judge. So, what do you think? Was the judge too patient or just perfectly composed? Let us know in the comments. And if you found this case as shocking as we did, make sure to like this video, share your thoughts below, and subscribe for more jaw-dropping courtroom breakdowns every week.